All right, I think this is really great. Hannah, we're already recording. Thank you. Great. Good afternoon, everybody. I think we're just gonna get started because we are at noon, but I see that we are getting other folks joining minute by minute. I'm really excited to kick off June by providing continuing legal education credits to attorneys through different webinars this month. Today we are going to be covering noise pollution. I just during legislative session, I think maybe some of you on this call were joining because of this. We're having a discussion about noise pollution, and I'm just really interested in the mechanisms behind enforcement and how noise pollution fits into the Pollution Control Board. And Juliana Pino at Little Village Environmental Justice Organization forwarded me a recent presentation by Pollution Control Board members Mike Mankowski and Jennifer Van Wee. And I'm very excited to have them present for us and answer questions that we have about noise pollution. This is definitely an area we haven't covered a whole lot, and I'm going to be learning right along with you. So that is really exciting. And I do see Hannah had put into the chat, but maybe you want to do it again, Hannah, as we get people joining. If you do want to get CLE credit for this, please fill out the form in the chat and we will follow up with your certificate and materials. So please fill that out. We'll also put it in at the end as well. And Jennifer and Mike, do you want, I think you're going to present and then we'll go through questions at the end. Does that work?
Yep, that works for us.
Great. And yeah, just feel free to put questions in the chat during this, and then I will facilitate a question portion as we end. And just for folks, our next CLE is going to be January 9th, focused on wind and solar permitting. So I'm really excited to learn about these different issues along with all of you. So yeah, like I said, please fill out the CLE and I'll let Mike and Jen introduce themselves. So thank you so much for doing this for us.
Oh, you're very welcome. My name is Mike Mankowski, and I've been a board member since July of 2023. Prior to that, I've got about 20 years of experience. I worked at the Illinois Attorney General's office doing environmental enforcement. I worked at the Department of Natural Resources as the director of their oil and gas program. I also was a staff attorney there for a while. I spent some time at Revenue doing regulations, and then came here to the board. Jen Van Wee, do you want to introduce yourself?
Sure. Thanks, Mike. Hi, I'm Jen Van Wee. I've been a board member since September of 2020. I, like Mike, have been involved with environmental law and practice for about 20 years. I also started my career with the Attorney General's office. I spent about 13 years in the Chicago Civil Environmental Bureau. And then I had a few years of private practice in firms in both Milwaukee and Chicago. And then I made my way back to state work here in Illinois. So I'm extremely happy to be a board member. I love being able to do this type of work and be able to talk about it as much as possible. And I'm really glad that Mike and I are able to do this presentation to a wider audience because the two of us kind of were thinking of what are some things that are don't really get talked about a whole lot in the environmental arena, and noise was definitely one of them. And so we're excited that this gets a wider audience. So we want to thank the Illinois Environmental Council for providing this forum.
Okay, and with that, we're just going to get rolling here because I know everybody's time is valuable. So thanks again to the IEC for letting us be involved with this CLE and getting this out to more people. So today, let's see, let me get this. Okay, so here are the topics that Member Van Wee and I plan to cover. I'm going to do a short background on the board's regulations, and then I'm going to briefly discuss the two types of noise complaints available under those regulations. Then we're going to follow up with some noise pollution basics. The bulk of my discussion is going to be focused on the board's numeric noise pollution standards, which is one of those two types of complaints that can be brought. After that, Member Van Wee will discuss nuisance noise complaints and provide some information on how to file a noise complaint with the board. Finally, we're going to answer everybody's questions, we hope. So here I'd like to start with a brief history of the board and its regulations. In 1970, the General Assembly adopted the Illinois Environmental Protection Act, which created both the board and the Illinois Environmental Protection Agency. As a quick note, during this presentation, any reference to the act will refer to the Illinois Environmental Protection Act. That's 415 ILCS 5. For those of you who are unaware, here's some background on the board. The board is limited to a maximum of 5 members. Each member is appointed for 3-year terms by the governor with the advice and consent of the state Senate. And we're kind of on staggered appointments so that, you've always got some members on the board while they're, waiting for other people to come in and out, come on and off the board. Of the 5 members, no more than 3 can be of the same political party, and each must have some environmental experience, whether in science, litigation, or public policy. We've got our current members here, which Barbara Flynn Curry is the chair. And then we have Michelle Gibson and Angela Tin, as well as, me and Jen. So who are we and what are our roles? We are a small but important state agency tasked with protecting our state's public health and the environment. We are responsible for conducting rulemakings that adopt environmental regulations and are tasked with deciding contested cases in the environmental realm. So that's a sound complaint would fall under our quasi-judicial function where we can hear complaints from the public. Now let's get into the regulations, some background on the regulations. The Act authorizes the board to adopt regulations to administer its responsibilities under the Act. The board's regulations are found in Title 35 of the Illinois Administrative Code. The Act and the board's regulations are available on our website at the link provided at the bottom of the page. With that background behind us, we can now move to our discussion of noise pollution. As stated earlier, I will focus on the board's numeric noise pollution regulations. Under the Act, there are 2 types of noise pollution complaints that can be brought before the board. The 2 types were summarized in the case of Rohde et al. V. LTD Commodities. The first type is highlighted in orange and is a violation of the board's numeric noise regulations. This type of violation is more objective and requires the complainant to measure and record sound emissions to show that the alleged polluter exceeded the specific numeric noise limits found in the board's regulations. The second is highlighted in blue and is a nuisance noise violation, which is more subjective and requires the complainant to prove that the sound emissions unreasonably interfered with their enjoyment of life. Before getting into the numeric standards, I would like to discuss the basic idea of noise pollution. So what is noise pollution? The term is defined in section 901.101 of the board's noise regulations as the emission of sound that unreasonably interferes with the enjoyment of life or with any lawful business or activity. Another way to think of it is unwanted or disturbing sound. Sound typically becomes unwanted when it either interferes with normal activities such as sleeping and conversation, or disrupts or diminishes one's quality of life. So when we came up with the idea for this noise-related presentation, this Dr. Seuss classic was the first thing that popped into my mind.
All those schoolgirls and boys will wake bright and early. They rush for their toys and then, oh, that noise, oh, the noise. There's one thing I hate. Oh, the noise.
Hopefully everybody was able to hear that short video of the Grinch complaining about the Who's. And anybody that's ever read or seen the cartoon or read The Grinch Who Stole Christmas knows that the Grinch really hates noise. All those little Who's running around with their foo flounders, janglers, and boing bouncers definitely appear to be interfering with his enjoyment of life. But the question is, are they causing noise pollution? Maybe by the end of the presentation, we'll find out. So let's look at the effects of noise pollution. The effect of unwanted and disturbing sounds can be broken down into two categories: physiological and psychological. The physiological effects of noise are often observed as damage to the ear and temporary or permanent hearing loss. Sound pressure levels exceeding 120 decibels can permanently damage the ear, and highly impulsive sounds can even rupture the eardrum itself. Beyond hearing loss, research has shown that exposure to constant or high levels of noise can cause countless other adverse health effects. The psychological effects of noise can result in interference with speech and the mental and motor performance of individuals. Loud noises can distract listeners and make it difficult for them to hear and understand a speaker, TV program, or radio. It can also require a speaker to raise their voice level to be heard. Unwanted and disturbing noises also cause annoyance. Annoyance has been defined as an unfavorable reaction to a stimulus. The issue of annoyance can be especially important when it interferes with one's relaxation or sleep. In the earlier clip, our friend the Grinch appears to be especially annoyed by the Who's and their celebrations that keep him awake up on Mount Crumpet. Now that we've discussed the effects of noise pollution, I'd like to give you some background on the board's regulation of it. Unlike many other forms of pollution, noise pollution is not currently regulated by the Illinois or United States Environmental Protection Agencies. After the passage of the Act in 1970, the Illinois EPA administered a noise pollution control program for 4 decades. The agency's noise pollution efforts unfortunately ended after the retirement of their last noise expert in 2001. So it's been about, not quite 25 years since they've had a noise control program. In 1981, the US EPA concluded that noise issues were best handled at the state and local level and eliminated its noise pollution control program. So if IEPA and US EPA no longer have noise pollution control programs, how is noise pollution controlled in Illinois? The short answer is that it is almost exclusively regulated through citizen complaints filed before the board. According to the Act and board regulations, any person, including citizens and local municipalities, may file a complaint before the board for a noise pollution violation. In response to a successful complaint, the board may order the alleged polluter to cease and desist from causing noise pollution, take actions to abate the noise, and even pay civil penalties. Now we can move on to the board's numeric noise pollution regulations. So where can you find them? The underlying authority for the board to adopt and enforce noise regulations comes from sections 24 and 25 of the Act. The regulations adopted under this authority can be found in subtitle H of the board's environmental protection regulations. It's also good to note that in both the Act and the board's regulations, there are some exceptions to the established noise standards. The board's basic authority over noise pollution stems from section 24 of the Act, which states, "No person shall emit beyond the boundaries of his property any noise that unreasonably interferes with the enjoyment of life or with any lawful business or activity, so as to violate any regulation or standard adopted by the board under this Act." With regards to the numeric noise standards, that last line is the most important. The noise has to be emitted in a way that violates the board's regulations. Member Van Wee will address unreasonable interference later when she discusses nuisance noise. Unlike some other sections, the language of section 24 has not changed since the original version of the Act was passed in 1970. Section 25 authorizes the board to adopt regulations prescribing limitations on noise emissions beyond the boundaries of a person's property. It also allows the board to prescribe requirements and standards for equipment, as well as procedures for monitoring noise and the collection, reporting, and retention of data resulting from such monitoring. Since 1970, Section 25 has been amended and expanded multiple times. Under the current version of Section 25, the board is required to promulgate regulations to categorize the types and sources of noise emissions that unreasonably interfere with the enjoyment of life or with any lawful business or activity, and prescribe for each such category the maximum permissible limits on such noise emissions. Exception to these requirements have also been added over the years. The exceptions now found in Section 25 revolve around sporting events. Generally, the board is not allowed to set monitoring standards or prescribe limits on noise emissions from organized amateur or professional sporting activities. The one exception to this was added because of changes made at Wrigley Field in the 1980s. Many Chicagoans and baseball fans may remember the uproar that surrounded the Cubs installing lights and playing night games at Wrigley. I remember all that back and forth back when I was a little kid growing up in Chicago. At the time, many people thought that the noise and light pollution caused by night games would ruin the character of Wrigleyville. As a result, the General Assembly amended Section 25 and granted the board limited authority to set nighttime noise standards in Chicago for any stadium that did not have nighttime events prior to July 1st, 1982. From the research that I was, from what I was able to find, it appears that both Soldier Field and Old Comiskey, prior home of the White Sox, held nighttime games, prior to 1982. And Wrigley's first night game was played on August 8th, 1988. So it seems, pretty obvious that the exception was aimed at, the Wrigley renovations. Another change was made when New Comiskey Park, now known as Guaranteed Rate Field, replaced Old Comiskey. As you can see in the picture, those stadiums were built right next to each other. And since the stadium was built by the Illinois Sports Finance Authority, the General Assembly created a new exception to get around the Wrigley rule by exempting stadiums built by the ISFA within 1,500 feet of a stadium that was, not previously subject to the Wrigley exception. So, once again, that language is pretty specific, and we know that it was drafted specifically for New Comiskey Field when it was built back in '91. So even the board's Wrigley authority is further limited by exempting World Series games, playoff games, and baseball all-star games. So as a lifelong White Sox fan and, any other Chicago baseball fan knows those exceptions have not really come into play that many times because we just haven't had enough playoff and World Series games. So hopefully one of these days we'll get to use them a little bit more. So now I'm going to dive into the board's noise pollution regulations, which are found in subtitle H. These include parts 900, 901, 902, 903, 905, and 910. So part 900 includes pertinent noise pollution related definitions, measurement procedures, and incorporations by reference. Part 901 provides the actual numeric noise pollution standards themselves. And part 910 includes all the board sound measurement procedures. In the interest of time, parts 902, 903, and 905 dealing with sound emission standards for automobiles and snowmobiles and the control of noise at racing facilities will not be covered during this presentation. But I just wanted to, note them so that you're aware that they exist. And maybe in the future, we could, do some more presentations on that. So part 900 includes section 900.102, which is the standard prohibition on noise pollution in Illinois. This section prohibits a person from causing or allowing the emission of sound beyond the boundaries of their property that causes noise pollution in Illinois or violates any of the board's noise pollution provisions. An important takeaway from this section is that the board's noise regulations apply only to the emission of sound beyond the boundaries of one's property. So it's not noise levels on your property. It's anything that, travels beyond your boundary. So I'm now going to move on to the board's enforcement of this prohibition on noise pollution with regards to the part 901 numeric standards. In general, the board's numeric noise standards found in sections 901.102 through 901.106 are applied based on the type of land that receives noise emissions and the type of land from which the noise emanates. The source of the noise is also important, as only property line noise sources are subject to the regulations. As you can see from the definition in the slide, to be considered a property line noise source, the source must be capable of emitting sound beyond the property line of the land on which it is operated. To apply its noise regulations, the board uses the Land-Based Classification Standards, or LBCS, to classify land. The LBCS uses numeric codes which designate land use functions. The applicable LBCS codes are found in Appendix B to Section 901. They are divided into classes A, B, and C. As we will see in a minute, Class A lands are generally residential and institutional. These are lands where most people would have a lower tolerance for undesirable noise emissions that interfere with their ability to rest, relax, and enjoy their property. Class B lands are generally commercial and business related. Class C lands are industrial. Because Class B and Class C lands are not generally used for residential purposes, a higher amount of sound is reasonable in these areas. The board's regulations account for this. For example, a residential receiver is protected more than an industrial receiver, while on the other hand, an industrial emitter is allowed to emit more noise than a residential emitter to the same class of receiving land. Lands that do not fall under Class A, B, or C are designated as unclassified or U. The board's numeric noise standards do not apply to unclassified lands. One other quick note, local land use zoning ordinances have no bearing on land classification under the board's subpart H regulations. The board will look to the LBCS and not the local zoning code when determining the land classification. So here are some selections from Appendix B for Class A lands. You can see that Class A lands include things like private households, hotels, schools, and health and human services providers. Class B lands include things like retail merchants and other service providers, food services, amusement parks, and camping related establishments. So even though, you may be, sleeping at a campground or something like that, they, usually allow for a little bit more noise than if it's just in a residential area. Class C lands include manufacturing, transportation, and agricultural related facilities. Because the board's regulations do not currently address noise emissions from air transportation, these lands are listed as unclassified in Appendix B. So anything related to air transportation is not covered by our regulations. Okay, besides the type of land at issue, the time of day also matters. The board has adopted separate numeric sound limits for daytime and nighttime hours for sound emissions from any Class A, B, or C land to any Class A receiver. So daytime hours are considered 7 a.m. to 10 p.m. local time, and nighttime hours are the rest of the day, which is 10 p.m. to 7 a.m. local time. The numeric limits for daytime hours are less stringent than for nighttime hours, which we're going to see in a second. Okay, one last thing to consider before we look at the actual numeric standards is the way that the board's regulations require sound to be measured. In simplest terms, the board looks at a sound's frequency and its decibel level when measured on the receiving land. For ease of measurement and description, the frequency range for audible sounds has customarily been divided into intervals. The basic interval used is the octave band. The octave band is separated into 9 frequency bands measured in hertz. They cover an overall frequency range of 22.4 hertz to 11,200 hertz, which is meant to represent the typical hearing range of a person. The board noise standards are based on the allowable octave band sound pressure level specified in the regulations. And the board's rules define octave band sound pressure level as the sound pressure level for the measured sound contained within the specified octave band. The reference pressure is 20 micronewtons per square meter or 20 micropascals. So we'll see in a second, how the sound pressure levels are used by the regulations. So after all that background, let's look at the numeric sound standards themselves. Here are the general limits for property line noise sources emitting from a Class A, B, or C land to a Class A receiving land during daytime hours. You can see how the 9 octave bands are implemented. Because different sound frequencies have different effects on the listener and on structures, the decibel limits differ depending on the frequency. Lower frequencies do not typically travel as far as higher frequencies and therefore are allowed at a higher decibel level. Notice that the measurements, you can see at the bottom of the paragraph there, that the measurements must be taken on the receiving property at least 25 feet from the property line noise source. Instead of measuring the noise from the emitter's property line, the measurements are required to be made on the receiving property, which allows for some atmospheric attenuation of the noise. You may also notice that for emissions to Class A lands, the limits for Class C emitters are less stringent than Class A and Class B. The additional noise emissions permitted for Class C property are an attempt to weigh the benefits accrued from industrial emitters with the costs for noise reduction. So you'll see, like at the 31.5 hertz, that's that would be a lower frequency. So that's got a, higher allowable sound level. Whereas, the higher pitch things down towards, the 8,000, 4,000 hertz, they have a much lower limit. And then you can see, for, like the 8,000 hertz Class C is at 40. So that's a little bit higher than the 32 that's allowed for Class B and Class A. And then here are the nighttime limits for Class A, B, and C emissions to a Class A receiving land. And I just put them here side to side so you can see the limits for nighttime hours are more stringent than the limits for daytime. The board standards reflect the fact that most of the population sleeps during nighttime hours and needs those hours to rest for the next day. This goes back to the psychological effects of noise pollution that we discussed at the beginning of the presentation. Disturbing a person's sleep leads to annoyance and definitely interferes with their quality of life. For sounds emitted to Class B lands, there are no separate nighttime standards, which reflects the fact that these lands are not typically used for residential purposes. So you can see there's just, it's the same standard throughout the day. So now that we've looked at the tables, here's a quick example of how to read them related to noise pollution. So in this example, let's say that we have an apartment located above a bar that's situated on the building's lower floor. So the bar is on the main floor and, there's an apartment directly above it. The apartment would fall under the LBCS code of 1100, which is highlighted at the top, as a private household. And you can see from the side, the column all the way at the end, that a code 1100 would be considered Class A land. And the bar should fall under code 2540, which would make it a Class B. Therefore, on like karaoke night or during any other loud events at the bar would have to comply with the nighttime or the daytime and nighttime standards and make sure that things quiet down after 10 p.m. to avoid potential noise pollution complaints. So that's why I highlighted the, class B to Class A. You can see, during the day, they, they're allowed higher emissions versus at night, it gets knocked down by about, not quite 10 hertz or 10 decibels after 10 p.m. So besides general noise, the board also has special rules for what's called highly impulsive sounds. Highly impulsive sounds are generally loud noises with very short, under 1 second durations. Examples of this are drop forge hammers and explosive blasting, both of which have their own specific rules. So other examples that don't have specific rules are things like firearms discharged on private property, devices like propane cannons used to disperse nuisance birds, tractor trailers loudly hitching and unhitching, and backup alarms on commercial vehicles. Those last two, the tractor trailers and backup alarms, those kind of things, those have popped up numerous times on the in board cases, and with more and more of the big warehouses and things like that going in, we'll probably start seeing more. We'll continue to see those types of cases. So like in other sections, highly impulsive sounds must be measured at least 25 feet from the noise source. And for Class A receiving lands, there are daytime and nighttime standards. So if the highly impulsive sound is, being emitted to a Class A, there's, we've got that daytime and nighttime standard. So in the interest of time, I will not be able to address some of the other sections in part 901, including specific standards for impact forwarding operations, prominent discrete tones, and highly impulsive sound from explosive blasting. But please be aware that they are included in our regulations. And once again, if there's people that are interested, maybe at the board or with the IAC, we could put on a later presentation. But those don't come into play a lot. So we're trying to stick to the more general rules that we have. So now I'd like to go over some examples of exceptions that are found in section 901.107 of the board's noise regulations. So as you can see from the first exception, our friend the Grinch might be out of luck if he was in Illinois. If the Who's were making noise in their private households or at a religious institution, then their exemptions would be, or their emissions would be exempt from the numeric noise standards, because they'd fall under that code 1100 and or the 5500 or 6600. So their standards, our rules wouldn't apply to them. A few other exceptions that might be of interest are emergency warning devices, lawn care equipment used during daylight hours. So that daylight hours is important there, and car and motorcycle racetracks. It is also important to note that the board's regulations specifically exclude equipment used for construction activities. That's something that historically we have not been given any authority over. So, as it stands right now, we don't regulate those from a noise standpoint. Besides those exceptions, there are also site-specific operational levels and noise emission limitations found in sections 901.114 through 901.122 for certain facilities located within the state. So, you can follow that link that's earlier up in the slides and, look those up if you'd like more information. So now I'm going to change gears and look at the board's sound measurement procedures. In order to prove a violation of the board's numeric noise regulations, a party is required to provide accurate measurements of any alleged sound emissions. Because we're looking at the actual numeric levels, so we need measurements. Sections 900.103 and part 910 of the board's noise regulations provide detailed information related to measuring and recording noise emissions. And to be honest with everyone, a proper discussion of these measuring procedures could be its own presentation. So this slide only provides some general information. Section 900.103B controls which measurement procedures are required, including things like LEQ averaging and correcting for ambient background noise. So that LEQ is the equivalent continuous sound pressure level. I'm not going to get in a bunch of nitty gritty on that. And then part 10 details the measurement procedures that must be used, including proper instrumentation, measurement techniques, and protocols for determining sound levels. Now it's going to sound like I'm glossing over all those measuring requirements, but going into too much detail is beyond the scope of this presentation. The nitty gritty of taking accurate sound measurements is something that may be different for each situation, depending on what the emitting property and the receiving property is, and what might be in between the noise source and the recording equipment and things like that. So instead of focusing on the equipment, what equipment to use and what protocols to follow, I'm really just going to focus on one really important thing. Please follow the rules. In numerous cases, the board and the courts have stressed that when alleging a violation of the numeric noise standards, the board requires strict adherence to the sampling and recording requirements. I mean, that term comes up multiple times in the in our decisions, and then anytime that someone's appealed one of our decisions, when it's gone before the courts, that strict adherence comes up a lot. So make sure to follow the regulations to a T. If you have a consultant, make sure that they are familiar with the requirements before sampling. If you are a consultant, read the requirements and follow them. As you're going to see from the examples I'm going to go over here in a second, there's been times that consultants just did what they did and handed in their report and missed key important requirements in our rules, which cause problems for the complainant. So in numerous cases where exceedances have been documented, the underlying numeric noise complaints were dismissed because the party measuring the noise failed to follow the rules. For example, in our first case, Manarchy, a case involving noise from a bar, the consultant failed to perform the required corrections for reflective sound as required by the regulations. So, they did a lot of other things right, but they missed that correction. So the board couldn't accept their sampling. In Charter Hall, a case involving noise from a trucking operation, the regulations required the consultant to be present during the entire testing period. The consultant failed to do this by leaving the site after setting up the equipment. So even if the sampling that they did, if it was accurate, all the other things being considered, since they left the site and weren't there monitoring it the whole time, the board wasn't able to accept that, in that case. And in Rhodey, another case involving trucks and warehouse equipment, the consultant collected evidence of sound emissions, but used the wrong averaging interval in their final analysis. So in these cases and in many more, the board and the courts found for the respondent because the complainants didn't follow the rules. So the respondent would be the one that was being alleged to have been making the noise. So in fact, I was unable to find a single successful numeric noise complaint in our files because in every case, the complainant made some mistake in the sampling. So, as it stands right now, we have not had a successful numeric noise complaint because, there's a technicality where someone didn't follow the rules, and because the rules weren't followed, the board couldn't find in favor of the complainant. So if you remember nothing else from this presentation, remember that a successful numeric noise complaint requires strict adherence to the measurement procedures. That's strict adherence. So if anybody remembers the commercials from the 80s, make sure you stick to those rules like crazy glue. So that's the end of my part on the numeric noise standards. I'm going to hand this over to Member Van Wee, and she's going to discuss nuisance noise violations. So thanks everybody for listening. I'll be here for questions after Member Van Wee is done.
Thank you, Mike. All right. I'll bring this up. All right. And here we are. Thank you again, Mike. As you guys can see, the board's numeric noise regulations, and as you will see, the nuisance noise regulations will illustrate a very interesting contrast. As Mike explained, the numeric noise regulations are highly technical and specific, and in fact, the rigorous requirements of those regulations haven't been met, such that a violation has even been able to be found. Conversely, the board's nuisance noise regulations have entirely grown out of its case law. So I will be looking not only at where the board's authority comes from, which, as Mike explained, is the act and the board's regulations, but also how the board has refined what noise pollution is and what kinds of things have typically risen to the level of noise pollution over the years. So it bears repeating, going over the definitions again. Section 23 of the Act states that the General Assembly's recognition that excess noise impacts citizens in many ways, and that the purpose of the Act, of the title, is to prevent noise which creates public nuisance. Section 24 of the Act goes further and states that no person shall emit beyond the boundaries of his property any noise that unreasonably interferes with the enjoyment of life or any lawful business or activity, so as to violate any regulation or standard adopted by the board or under the Act. So now let's look to the board rules. Section 900.102 provides that the prohibition on noise pollution It states that a person must not cause or allow the emission of sound beyond the boundaries of that person's property. And as defined by Section 25 of the Act, that causes noise pollution in Illinois or violates any provision of the chapter. Okay, so let's look how the Act defines noise pollution. Noise pollution is the emission of sound that unreasonably interferes with the enjoyment of life or with any lawful business or activity. But here's the thing. How do we determine what is reasonable or unreasonable interference for what is arguably something that can be highly subjective, such as noise? Think about the different types of noise. A dog barking, a baby crying, nails on a chalkboard, train noise, church bells. I'm sure I could find some people who would find some level of all of these things unreasonable. So how do we determine what is unreasonable noise? We look to case law. In Charter Hall Homeowners Association and Jeff Cohen versus Overland Transportation System and DP Cartage, this was a citizen enforcement action concerning a trucking terminal in Palatine, Illinois. The respondent Overland leased the trucking terminal to respondent DP Cartage, which operated the facility. The complainants, a homeowners association, and homeowner alleged that the noise from the trucking terminal exceeded both the numeric sound limits and unreasonably interfered with the lives of the residents living immediately east of the facility. Overland operated the facility as a motor freight terminal for loading and unloading of trailer trucks virtually 24 hours a day. Interestingly, before the respondents had operated on the property, another trucking terminal had operated there, but the noise it generated either didn't disturb the complainants or it disturbed them much less frequently. The complainants alleged 3 types of noise specifically: the banging from the hitching of the trailers, the banging from forklifts, and the metal dragging. In Charter Hall, the board outlined a 2-step inquiry to determine whether the noise emissions rose to the level of nuisance noise pollution violation. Step 1 was whether the noise constituted an interference with the enjoyment of complainant's life, and 2, whether the interference was unreasonable considering the 33C factors of the Act. All right, step 1. Whether the noise constitutes an interference in the enjoyment of complainant's life. The board has found that sound from a source must objectively affect enjoyment of life to constitute an interference. So what does that mean? In Charter Hall, the board found that meant that the noise disrupted their sleep, it restricted their ability to use their patios and backyards, it required them to close their windows, it disrupted TV watching and normal conversations, and it limited the residents' ability to entertain guests. In other cases, the board has found interference to include sleeplessness from nightclub noise, that was in the Monarchy case, interference with sleep and the use of their yard, that was the Hoffman case, interference to sleep, watching TV, and conversing from truck operations, that was the Thomas case, and interference from sleep from a live music venue, that was the Pfizer case. Now that we've found there's been an interference, we move to step 2. Whether the interference is unreasonable. And now we look at the 33C factors of the Act. The board considers the 33C factors to determine whether the noise rises to the level of a nuisance. As many of you know, the 33C factors are used in enforcement cases to determine the reasonableness of emissions, discharges, and deposits. They include 1, the character and degree of injury or interference with the protection of health, welfare, and physical property of the people. 2, the social and economic value of the pollution source. 3, the suitability of the pollution source to the area in which it's located. 4, the technical practicability and economic reasonableness of reducing or eliminating the emissions, discharges, or deposits. And 5, any subsequent compliance. It's important to note that the board need not find against a respondent on each factor to find a violation. Rather, the board evaluates each factor and usually finds for the complainant, respondent, or finds that a particular factor is neutral. At the end, it's the totality of the findings for each factor that are looked at to determine if a violation is warranted. I won't go through each factor, but some factors have been looked at in more depth with regard to nuisance noise. When looking at the character and degree of interference, in Charter Hall, the board cited to the this is a hard to pronounce case, Racket case, which stated that the board asks whether the noise interferes with the complainant's enjoyment of life substantially and frequently, beyond minor trifling or annoyance or discomfort. So think back to my first slide, where I made mention of the list of noises. A dog barking, a baby crying, nails on the chalkboard, train noise, church bells. All these things probably can be handled for a short duration. But if those noises were constant, day in, day out, nonstop, then think of it. In the Vassik case, the Vassiks live near St. Michael's Lutheran Church in LaGrange Park. The church had an electric carillon that transmitted from 4 speakers attached at the roof. The complaint alleged that the sound emissions consisted of the amplification of chimes, songs, and gongs emitted from the loudspeakers hourly from 9 a.m. to 6 p.m., and that the songs are played from 7 to 10 minutes daily, 7 days per week, from 12:30 p.m. and 5:30 p.m. And additionally, on Sundays, the songs are played at 7:45 a.m., 10:30 a.m., and 11:30 a.m., and a gong is rung at 8 a.m., 9:30 a.m., and 10:45 a.m. The Cavics alleged interference with their sleep, conversations, and TV watching and radio listening. After hearing the testimony of the witnesses for both parties and considering the 33C factors, the board found the record did not support a finding that St. Michael's had caused noise pollution. It's a short but interesting opinion, and it includes a dissent from board member Dumel that's worth reading. I think from looking at the opinion that the 2 big factors in this decision were that the bells were rung during the day and that there was not a plethora of other neighbors that were complaining about this noise. In assessing another 33C factor, the social or economic value of the pollution source, in particular when the respondent is a business, the Illinois Supreme Court has looked at the number of persons that the respondent employed and whether the respondent is an important supplier to a particular market. The board similarly looks to such factors as the number of employees at a facility or the total wages and taxes paid. All right. So once a noise interference has been determined to be unreasonable and a nuisance noise violation has been found under the 33C factors, the board must determine the appropriate remedy. As with all board enforcement actions, we turn to the 42H factors. But we won't need all the 42H factors. Factors 6, 7, and 8 all relate to matters before the Illinois Environmental Protection Agency. And as Mike stated, the agency does not currently enforce noise violations, so those particular 42H factors do not apply. However, the remaining factors, 1, duration and gravity, 2, due diligence, 3, economic benefit, 4, deterrence, and 5, previously adjudicated violations, will all be considered to determine the appropriate civil penalty to be imposed. But the board does more than just issue civil penalties. In fact, the board has quite an interesting history with nuisance noise remedies. In Young versus Young, the board directed respondent to file a report detailing a plan for reducing noise emissions reaching the complainant's residence. And in Pawlowski, the board prohibited the bar from using a jukebox and speakers next to the complainant. In Village of Madison versus Discovery South Group et al., the petitioner Village filed an administrative complaint against the respondent amphitheater for noise pollution. The board found for the village and ordered the amphitheater to conduct sound monitoring for 3 years and to maintain specific sound levels meeting the board regulations. The amphitheater appealed the board order. The appellate court affirmed the board order and upheld the board's required sound monitoring. The appellate court held that the amphitheater admitted sound that unreasonably interfered with the enjoyment of life and many of the village's residents. In Rhodey v. LTF Commodities, LTF ran a warehouse operation at its site before the residents built and moved into their homes. But LTF subsequently increased its operations and noise level. The noises consisted of tractor-trailer noises and backup beeper on a yard tractor used at the site. The residents contended that the noise was more disturbing than that of the nearby toll road and the corporate office park. The board directed respondent to cease and desist the noise violations. The board gave LTF the option of ceasing nighttime operations, no longer using the backup warning beeper at its facility, and ceasing idling trucks, or it could build a noise wall if it wanted to continue night trucking operations, and the board issued a $15,000 penalty. On appeal, the appellate court upheld all of the board's findings. The appellate court found that the board did not err in finding the company's operations were noise nuisance, in ordering the company to shut down its nighttime operations, in ordering the company to disconnect its backup beepers, in ordering the company to consider building a noise wall, or in fining the company. The board continues to get noise complaints filed before it. In fact, the recent influx of noise complaints is what inspired board member Mankowski and I to present on this topic. We also have been getting quite a few inquiries about noise related to pickleball courts lately. But here are a few cases that have actually reached the filing stage. In the James Pfizer and Henry Double K case, Mr. Pfizer alleged that the noise from a neighboring bar and live music venue unreasonably interfered with enjoyment of life, including the sleep of he and his wife. The bar was situated across a valley from the Pfizer house, which seemed to amplify the noise. Despite some attempts to reduce the amplification and external noise, the issue persisted. On January 21st of 2021, the board found for a nuisance noise violation and ordered a hearing on remedy. In December of 2021, the parties jointly dismissed the case with prejudice. Another case is the Merritt Crook versus New Trier High School. Mr. Crook alleges that noise from a dust collector used for a wood shop and other equipment emits excessive sounds. New Trier's undertaken some sound sampling to demonstrate its compliance. New Trier filed a motion for summary judgment, but was denied in April of 2022. This opinion and order is worth taking a look at because it provides an interesting discussion of the burden of proof on summary judgment, and the parties are currently discussing settlement. This is also a good case to look at because there were some numeric sound measurements taken by a consultant, but they didn't strictly comply with the board's requirements. And as Mike has said, I mean, the requirements haven't really changed, but for some reason, people don't look to them before they do the sampling. So that is a really good recent case that shows you can have a lot of data, but if it isn't taken the right way, it actually ends up being fairly worthless. when it comes to the numeric case. Now, you can still use that information in the nuisance, making a claim for nuisance, but it's merely persuasive. It's not. It isn't a just because you violated a numeric standard and you can show it, it doesn't necessarily mean you violated a nuisance. It doesn't prove nuisance, if that makes sense. Another recent case is the Philip Carper versus Top Flight Grain Cooperative. This is noise related to the operation of a grain elevator conveyors, fans, and motors. This matter is still pending with the parties, and the parties are in settlement discussions. This is an interesting case that was filed not too long ago. The people, which was in this case, the state's attorney of Lake County versus the Illinois Department of Transportation. This was noise related to the installation of transverse rumble strips on US 41 in Lake County. And in March of this year, the Lake County State's Attorney's Office filed an unopposed motion to voluntarily dismiss the complaint. They didn't exactly explain why they dismissed the complaint, but I was looking forward to hear more information about this case, but it got dismissed. So another case that is making its way to the order stage is Doug and Jerry Boyer versus MRB Development, doing business as Copper Fire. This is a noise from a restaurant and live music venue. On August 8th of 2024, the board granted summary judgment to the respondents on the numeric noise pollution claim, meaning that the complainants did not make out their case on the numeric nuisance claim. But summary judgment was denied on nuisance noise, so that was allowed to proceed. And the board directed hearing to proceed on the nuisance noise. The hearings were held in October and November of 2024, and post-hearing briefing was completed in early 2025. So I would expect that a board order will be issued in that relatively soon. And in one of the final cases, Anna Andrushko versus Thomas Egan. These are two neighbors. She is complaining that her neighbor has an escalating pattern of using noise and vibrations from his stereo and noise from his car horn and barking dog to irritate and harass her and her cats while in her backyard and home. In January of 2025, the board denied Mr. Egan's motion for summary judgment, and Mrs. Andrushko has now filed a motion for summary judgment while discovery is progressing. So as you can see, we have quite a few nuisance noise cases that have been before the board recently. And if you're interested in finding out information on any of these cases or any of the board's cases, we would encourage you to visit our website. There's so much information there, and including the board's rules and the Environmental Protection Act. You can find, you can go and search for a case related to noise. If you have a specific case number, you can look that up. It will give all the orders in that case, including transcripts, things like that. And if you're interested in filing a complaint, there are sample complaint forms that you can look at, and you can look through that and see if that's something that you might want to consider. So we encourage you to explore our website, and we thank you again for giving us the opportunity to speak to you. This is some information about our office, and we recently moved in Springfield, so this is the most up-to-date information on our Springfield office. And I think if there are any questions, Mike and I will do our very best to try and answer them.
I just wanted to interject one thing real quick on on filing a complaint, because this is something that comes up from time to time. And, from a citizen's complaint standpoint, that if you file a complaint before us, it's a legal proceeding. So it's not the same as like calling Illinois EPA and making a complaint and expecting, them to send out inspectors and determine what's going wrong. If you file a complaint before the board, you're driving that train. It's an administrative case, but you're basically the plaintiff. So you are, or engaging in a legal proceeding with another party. So you have to, be involved with legal discovery. You have to provide the evidence to, support your claim, those kind of things. The board doesn't have, a crew of inspectors or investigators or anybody that goes out and conducts that part of it. So it's a little different than, calling the county or calling EPA or somebody else to, complain about the noise or other issues. So I just wanted to get that out there since we had a link to the complaint form that, it's a different world, because we've had that before where citizens file something with us and then they are unhappy when we're not able to, do the legwork for them. So just, for anybody on the Zoom, I wanted to make that clear.
Well, thank you both for that really excellent presentation. I know I have a few things, then I'm going to take some that are related to some of these questions that are in here. And I do want to, for folks who are on for CLE, please make sure that you go in and you review that the CLE is filled out correctly and that you got all the info in there. That's the only way that you can get it, is if it's in there. And we will reply with their certificate in a number of days. And I'll end with when some of our next ones will be. But thanks for taking a few questions. Yeah, this is really fantastic. I think some of these you ended up answering later, but why don't I just give a few as an example? Somebody asked a question about loud leaf blowers as a major stressor. Do you want to maybe, I know you can't give like what the decision would be, but how would you look at something like a loud leaf blower as a specific noise pollution?
And that's if you remember, at least from the numeric standpoint, that's one of the things that's there's exceptions for that. If you're using lawn equipment during the day, then the board doesn't have any authority over that. It could also come down to if it's a neighbor to neighbor issue. That's unfortunately the way that the rules were promulgated after hearings, back in the 70s, and then every time that it's been amended since then. Things that happen at residences are kind of out of our authority. So we may not, if you had a neighbor that had a loud leaf blower, we may not be able to do anything. You can still file a complaint and then we could see where it would fit in. At least from the numeric standpoint, you'd have to get decibel ratings and, readings and things like that. But it may not fall under our authority, especially if it's during the day, because there's a clear exception for that. Now, if they're out there trying to annoy you, blowing it at, midnight or something like that, it's hard to say which way it would fall out. But if it's class A emitter to class A receiver, we may not have any authority over that.
Great. Well, thank you. I know I got a couple. One of the reasons this came up was with respect to noise modeling for wind turbines. Can you talk about like how often modeling is required in to get a permit for specific industries, and like what role you all might play in the precursor to some of that?
I'm not sure. I don't know if Jen is, that may be something we have to get back with you on, because I hadn't really thought about that issue from this.
Should have asked it in the meeting.
Yeah, I was thinking more of, I think we were prepared for this more for complaints that something that already exists and is making noise. I'm not familiar personally with, noise requirements on the front end to ensure that entities being permitted, that they what they need to follow for that. So I wouldn't want to just expound on that. off the cuff.
I'm not aware of anything we do like on the front end for anything, any permitting. Um, any involvement on that I think would probably fall outside of our purview. So
Okay. Um, do you want to talk a little bit about how this interacts with local jurisdiction ordinances? Somebody asked if there was a database where there are the actual sound nuisances. I mean, I don't know if you keep that, but how does it interact when a community has their own regulations?
Jen, you want me to? I mean, I could start on that one. Since our authority comes directly from the statute, from the act, and it really only gives authority to us and Illinois EPA. We're bound by that act, and then we've got the rules that we promulgated under that. Our act doesn't really affect the local municipalities. They've got their own police powers that they can create ordinances and other things for. So they're kind of independent to what we do. There's some situations where you might be able to file, a complaint with us, and there could also be local ordinance issues, that you could pursue. So they're kind of, they run parallel to each other. Our one doesn't really affect the other. If people wanted to look up, this is a CLE. If you've got access to Lexis or Westlaw, I know we've been using Lexis for the last few years with the state, but I was pretty sure Westlaw had it as well. There's all of our pollution control board decisions have their own database on the for legal research purposes. So somebody in the chat had asked about the people doing the bucket drumming in downtown Chicago and things like that, and I just did a quick search to see, and I didn't see any decisions on our end that related to the bucket boys, but that's one place that you could look to see for prior decisions that we've had on noise related issues. You can also go on our website, where Jen had provided the link. You can sort through all of our decisions and rulemakings by media type. So you could look up every noise related issue that we've had before the board. And I mean, our database goes all the way back to 1970. So Member Van Wee was talking, I was looking back at the rulemakings from the original noise rules from the early 70s, and that's on there, if you want to look at the opinions and any noise related complaint that we've had, you can look up for enforcement, and then look at noise. You can sort by case type, which would be enforcement, and then or administrative citation possibly, and then media type, you can look up noise. So you could search our database to find that information for previous cases that we've had. I'm not aware, if you were trying to search for all the different ordinances across the state for different communities and things like that, you'd have to go to their website, or I know there are some aggregating websites out there where you can find those. But I mean, that's one of the things, because that's on some of the cases we've had lately, like the Andrushko case and things like that. There's been discussion of the local ordinances within the complaint filed before us, and there's nothing that we can do at the board to enforce those. So that's something that normally would be kicked out on our end if a complaint was filed before the board.
Cool. Just looking at some of these questions, I just wanted to maybe end with a couple of questions. I'm sorry I'm not asking specific things that are in here, but I think, some of these are you kind of answered, or they're kind of overall. Or if it's very specific, you all should maybe do some research of the attendees here. But I think there's a couple of places that these lead to. So I think first, is there anything, we work on a lot of policies, so hopefully this isn't too much of a spot, but is there anything that you think policy-wise would make it make enforcement of these cases easier for you all? Like anything that you would change from a legislative perspective? And while you're thinking about that question that I'm sure you haven't thought about, maybe providing a little bit on, things you can learn from these cases that might apply to other aspects of environmental law or the case making that you're doing, the decision making that you're making. Just as a policy, what do you think works and doesn't work?
And I think this is kind of always our blanket response as board members, because we may get a case that comes before us, specific facts and things
Yeah.
like that, that we generally don't get involved with policy discussions on our end, just because, since we have that quasi judicial role, we try not to push the policy. It's just, if the act gets amended, we respond to it. If we're required to, promulgate rules or review Illinois EPA's rules after there's been a statutory change, that's just, that's the hand we've been dealt. So, I know we don't normally, we may have personal opinions on things, but as a board member, we try not to direct policy in either direction, because at the end of the day, we have to implement it, whether we like it or not, we have to implement it. So, I don't know if, I don't want to speak for Member Van Wee, but that's kind of the policy I've taken, versus previous roles where I had, I was in charge of policy for an agency or something like that, then yeah, I definitely have opinions on things, but rather not bring them up here. But
Yeah, that makes sense.
It's always on our end, is if the statute is as clear as possible, that makes our lives easier. If if the legislature or the proponents of the legislation, if they want to put more detail and more requirements in there, that's helpful. Sometimes that kind of, if you make it too detailed, then it doesn't give the agencies the ability to, adjust without having to change the statute. So that always makes things difficult. I know from my, previously working with the oil and gas industry, if they give some flexibility where you can write rules to change things as technology advances, that's more helpful than setting things in stone. Or like I know from doing environmental enforcement, looking at the Environmental Protection Act, where it will cite to specific documents that were printed in like 1984 and you can't even find a copy of it anymore. That's obviously never helpful. So that's just kind of generic things that I've noticed after being an environmental practitioner for 20 years now. So but yeah, on the board end, specificity and clarity within the statute makes our lives a lot easier, because then we don't have to make it up as we go along, because it would actually be in the statute.
And I think in this arena where that's what makes noise so interesting, right? They were so specific when it came to the numeric noise regulations, and so unspecific when it came to nuisance noise, right? What's unreasonable, right? Like just so vague. But Mike and I are lucky that we are where we are now, because there's been so much robust case law from the board on this. They created the two-step test and really have drilled down what unreasonable is and what interference is and what noise pollution is, such that we have a lot of guidance for us. But when we're looking at something and we're looking at a set of facts before us, we have a lot of to work from, to say, okay, what is this rising to the level of? I think probably when it first came out, it was just gut check. I mean, it was a lot more individualized to the board member. But we're lucky enough that we've gotten some really good opinions that have laid things out, and so we have a lot more direction, and that's been upheld at the appellate court. So we've gotten a lot more clarity. So I think we're good.
Yeah,
That's
and
okay.
going back to, if people have the time and are really interested in it, going back to some of those early board orders from the 70s when these rules were passed, they put a lot of effort in. They had hearings all across the state, and they really tried to balance the interest of the industries and things like that, and then private landowners, citizens, people that just want to get some sleep. And I know, like, one of the things in the comments was about the this is weighed more for people that have a traditional 9 to 5 type schedule where they sleep at night. And as of right now, if you are you work at night and you're sleeping at 11 o'clock in the morning, it just doesn't help you as much. But that was, that was one of the things that was weighed. If you read through those early decisions, the same thing with the board not wanting to get involved with residential disputes, because that usually involves, the authorities and things like that at some point, that, that's something that we just don't have the ability to handle. So I will, if you really are interested in noise, reading some of these old board orders it's pretty interesting how much effort they went into to try to promulgate these original rules to balance things as best as they could with the authority given through the statute. So
Great. Well, thank you so much. And I think somebody, there've been a couple questions about light pollution. Um, and oh, and then there's now a question about whether wildlife has ever been considered. Do you want to, those should be, I don't think there are any light pollution laws in Illinois other than the one we did for DNR, which has nothing to do with you all, but yeah, no light pollution, right?
yeah, not that I'm aware of. And then on the
Okay.
wildlife standpoint, I mean, that may fall under, if somebody wanted to, I don't think I've ever seen a case where they argued that idea from a nuisance standpoint. And then I'd have to go through the rules again in more specificity, but I don't think that really comes up in our rules on the numeric end on, whether what decibel level may affect wildlife. And I wonder, I don't know if that was at all discussed during those hearings back in the 70s, and then, since any other time that it's been amended over the years. That'd be an interesting issue to look into. So, if you have questions like that, you can send them to us and we can see if we can find anything, and you could relay that to, your membership.
Super interesting. Yeah, this was really great. I don't think I have any more questions. I am gonna, the CLE thing is in the chat for folks who want to fill that out, and I'm putting in we are doing a blitz this month of webinars. Partially I need my CLE, so anybody at the last half of the alphabet, I know why you're here. But also for learning on these issues, there's a lot that came up, particularly this session we want to learn about. Some of these we're not totally solid on, but we're looking at wind and solar permitting, data centers, Chicago civics, with Rep Chair Ann Williams, who's on, looking at how an energy bill gets negotiated, maybe some legislative drafting, and then some of the future of gas workshops at the ICC will do a little bit of coverage. So I hope you all, will join us for this and getting your CLE with me, but this was really informative. We're gonna we have it recorded, so folks have questions later, send them by me, and we'll send out the slides in this recording along with certificates as soon as we can. So thanks to everybody, attorneys and non-attorneys who signed up for this, and thank you to the IPCB members, Jennifer Van Wee and Mike Mankowski, for leading a really excellent talk. This was really informative. I learned a lot that I think can be used in other places. So appreciate you, and everybody have a great afternoon.
You do the same. Thank you all.
Thank you very much. Thanks.
Bye.